federal suit, and as there is a motion to impeach the guardian ad litem, Joe Coyle does not have clean hands to bring forth this motion or allegation against a respondent or defendant. This court has denied Joe Coyle's motion to deem respondent a vexatious litigator, and Joe Coyle turned around and filed it 2 more times. To the respondent, this appears to be that Joe Coyle is now representing the petitioner. As the petitioner's attorney, David Bloom should be bringing this claim, not the guardian ad litem. The court appointed a guardian ad litem for the children that is not a minor at the time of the appointment. Not only is this court appointing the guardian ad litem voided, but the entire judgment is voidable under fraud. The respondent is in the federal court on September 12, 2017, which is why the December, received what she perceives as a death threat by David Bloom. Acting as petitioner's attorney, stated, "The plaintiff, me, will not survive the day." It is reasonable for the respondent to perceive that because even the federal judge herself, when it was initially said, question the motives of the opposing counsel. This offending, knowing the intimate details of this case, respondent still perceives this as a death threat as petitioner continually abuses the judicial system by and through vexatious litigation to threaten, intimidate the respondent with premeditated malice, forethought, and knowledge that this is the true definition of a vexatious litigant. Under B. Plasky v. CIA 953F2D 25, 26, and 28, Second Circuit, 1991, the court errors if court dismisses pro se litigants without instructions of how pleadings are deficient and how to repair pleadings. See Exhibit 7. This court must dismiss this action against the respondent with prejudice, as Joe Coyle and the petitioner are clearly acting in concert and have filed vexatious motions and various other claims against the respondent. Joe Coyle has no standing and is a non-party to this case to bring this against the respondent.
The exhibits that you've referenced, those that include rules or statutes, I do not need copies of those. The court could certainly take judicial notice of applicable statutes, case law, rules, and I'm very familiar with those. I think in part the problem that we're having here is that you're not a lawyer and you may have read some of the rules, some of the statutes, but your interpretation of some of them is wildly at odds with applicable standards in the courts. So I appreciate and I understand your frustration with custody disputes. I understand it's a very emotional issue, and it's one that I certainly can understand as a mother, your frustration with that issue. But the tactics that you've engaged in are an abuse of the powers of this court. The 5 filings for protective orders alone, I worry that you don't understand the purpose of those protective orders, and you're filing those which are frivolous. They've been denied 5 times. I've denied one of them myself, asking you to read the statement included on that protective order that you're potentially subject to criminal charges for filing a protective order when you know you don't have a basis to file it. There's a standing order giving custody to Mr. Malmstrom that's been entered. I know you're aware of that order. Despite your frustration with it and setting this matter for trial, the protective order alone on 5 separate occasions that's been denied, I suppose I'd like to hear from you, without reading a statement, why it is that you filed those 5 protective orders alone.
I have filed those protective orders to, I guess, my ex-husband, the petitioner, as he has continually came to my home. He sends messages. It's a constant from him. It's a constant harassment. The divorce was done after a domestic violence situation where I am very fearful of him. And because of his continually coming to my home and making allegations against me and bringing the police, I am in fear of him. I fear him because of what he's done to me. And I have a right to protect myself and defend myself. And that is why. So when I filed the initial one, I didn't know what to do. And they said, amend it and bring it back. So that's the reason I did it, was because I am in fear of what he has done and what he can still do. And I should have a right to be able to protect myself and my children and my home. And as the court has said, amend it and bring it back, and which I did.
I don't see a notation to amend it and bring it back on any of those.
I thought there was one by the first one that I saw when the court called me, they said that the judge said you can amend and bring it back, is what she told me. Because I asked her if I could refile it, and she said yes.
The most recent one?
The recent one, I didn't get a phone call on. But I figured it was denied because I didn't hear anything else. The most recent one was brought about because of the threat that was made in the federal court against me, a death threat against me.
You don't think that perhaps he was saying you wouldn't survive the day, meaning that you wouldn't prevail on the claim?
Well, that was why Judge First questioned it. Judge First thought, are you talking the petitioner, or the plaintiff, or are you talking about the claim? And he hummed and hawed for a moment, and he said, well, obviously the claim. But he had to think about it before he said it, and then he said it again.
Do you realize that accusing someone of making a death threat against you is a very serious allegation?
Yes, I do. But when it's made in an open court, where the judge herself, Judge First herself, had to question it, then yes, it is very serious.
All right, so your allegations of abuse against Mr. Malmstrom personally, and each of these allegations appear to be during the divorce, or otherwise instances where the police came to your house during parent time or to facilitate the exchange of custody.
Correct.
Okay, the police coming to your house to keep the peace is not grounds for a protective order.
No, I realize that, but him coming with the police and standing up the street with the police, yes.
How do you make that assessment?
Because he's abusive. I mean, it was domestic violence, the reason why we split up. And he's, with him being there, to me, it's very uncomfortable for him to be there. And that is part of the reason why he will not sign off on the house, so he can make a statement, he can set foot on the property. And making threats via text messages.
Yeah, I'm not seeing those threats to your personal safety.
No, I did not submit them, and I should have.
I'm not asking you to submit them. In fact, I'm telling you that you have filed now 5 requests for protective orders. Those protective orders are very serious
Yes,
requests.
I realize that.
This court stops all other actions to consider protective orders for people who are in immediate danger or threat to their safety from another person. And the allegations that you are making relate to a civil action, which need to be heard, but they are not appropriately considered as a protective order. If a police officer is there for a keep the peace, the fact that Mr. Malmstrom may be there, if he's not communicating with you and if there's a police officer there, that is absolutely not grounds for a protective order.
Okay, I did not understand that. But it is a threat. He has made threats against me. And because it's been an abusive situation this whole entire time, where he has threatened me. There has been open threats against me by both him and his attorney. Then yes, I need to be able to protect myself.
All right, I want to make another point clear. You are designated as the respondent in the divorce case.
Correct.
That's because Mr. Malmstrom filed for divorce against you.
Correct.
But this proceeding that is pending before the court is a petition to modify